good afternoon and a huge welcome to all of you from us at Jones Chase Employment Lawyers. And for those of you that are new to our webinars, we are of course a firm of specialist employment lawyers, and we work with a number of companies from PLCs all the way through to startups and also some fantastic individuals as well. And I'm very proud to say that we have a very high success rate of looking after those that we represent, which is north of 95%. And yeah, we're totally delighted to have you with us. And I'd like to quickly introduce the team as well. Those people that will be speaking to you today. Unfortunately, Zainab couldn't make it very last minute, so just the three of us today. We've got Harry, one of the firm's senior associates.
Hi, everyone.
And Carl, one of the firm's senior associates as well.
Hello, thank you for joining us.
And I'm the only person that hasn't worked out how to blur my background yet, so I do apologise about that. And I've also got a little bit of a cough as well, so I'm going to try and get through this without sort of coughing and sputtering too much, but there we go. Okay, right, just moving on. So in terms of the format of the webinar, if you want to ask us questions, please do so. You can use the Q&A box for that. You can also hit the anonymous button if you want to ask questions anonymously. And if you don't mind your name being displayed, you can use the chat box as well, which we'll also be keeping an eye on. What's quite helpful for us as well as hosts is, if you want people or the other attendees to see what you're saying, and there should be an option in the chat box and the Q&A box where you could select all panelists and attendees. So yeah, please use that one where possible, because that's quite useful to keep the chat flowing as well, so people can see what you're saying. If you want to speak live, we've only ever had one person do this in the history of doing these webinars. Please write that into the chat or the Q&A box, and either myself, Carl, or Harry will unmute you. And importantly, I should add that we are recording the webinar to allow us to distribute this to those that couldn't make it today. So just please bear that in mind if you're asking questions, and therefore, if you're worried about confidentiality, definitely hit the anonymous button, okay? And I should emphasize that the points that we're covering today are not formal legal advice, and so much depends on the facts of the case, and sometimes the approach that you take in one case is not the approach that you take in another. And therefore, please do not rely upon this webinar for legal advice, and do get in touch with us instead, because the context and facts are very important. Sorry, and as a quick reminder, the information that we're covering today is accurate as of 4 o'clock on the 21st of October. And things are always changing very quickly, so do drop us a line if you have any further questions. And we do appreciate that everyone's time is precious, and we're going to finish today at 5 p.m, if not before. I actually think that we're going to finish a bit earlier today, but every time I've said that, we never have ended up finishing early. But we'll see, so 5 o'clock at the latest we will end. And lastly, in terms of the introduction, we do like helping people. So if you know of anyone else or any companies or individuals that would benefit from our help, please put us in touch with them. We'd be delighted to have a chat with them. And just a quick reminder that we also act for individuals as well as companies as well. Okay, so today's chosen topic is recruitment. And of course, we've got a big surge in recruitment happening within the market at the moment. Lots of companies, employers are desperately trying to hire people, and ironically, there's a labour shortage. So thank you, Brexit, and thank you, the coronavirus, for everything that's happening at the moment. It's a slightly chaotic marketplace. But we thought it would be a really good idea just to have a quick chat with you about recruitment and the employment law implications of that. Zainab was going to cover pre-employment discrimination, so I'll quickly run through that as well. And also, sorry, just bear with me. Can you go on mute, Carl? Is that all right? Just 1 second. Yeah. Oh, sorry. That'd be awesome. Thanks. Yeah, brilliant. Thank you. Yeah. So we're going to run through pre-employment discrimination, and secondly, Harriet's going to run through a whole wealth of sort of really tricky employment issues relating to recruitment, such as making conditional job offers and withdrawing offers. And then Carl's got a pretty big section for him to do, which is to do with hiring senior executives and other employees who are subject to post-termination restrictions. So all quite complicated, and Carl will take you through that. He's actually done an awful lot of work in that area as well. So the first thing that we're going to quickly cover today is pre-employment discrimination. And the first thing that I'd like to say about that is that it exists, and it is actionable under the Equality Act 2010. Okay, and as I'm sure we all know, the Equality Act makes discrimination and harassment unlawful in relation to 9 protected characteristics. So we have age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. And the pre-employment discrimination provisions are actually very wide, and they cover discrimination, so that's direct discrimination, indirect discrimination, They also cover victimization and harassment in relation to recruitment. And all of this can be found in sections 39 and 40 of the Equality Act 2010, okay? Section 39 of the Equality Act says that an employer must not discriminate against or victimize a person in the arrangements it makes for deciding to whom, how to offer employment. Secondly, as to the terms upon which employment is offered. And thirdly, by offering or not offering employment at all. Okay, so it does cover a whole host of things. And then section 40 of the Equality Act is specifically about harassment, and it says that an employer must not harass a person who's applied for, well, I'll come on to that, who has applied for employment. Okay, the concept of arrangements is, as quite often with discrimination, exceptionally broad, and it can be in relation to sort of anything, I would imagine. So have a very expansive approach in terms of if you're thinking about it. So it can be the format and content of job application forms, it can be the physical arrangements, location and timing of interviews, and also the job and person specifications as well. And for example, a disabled person might complain that reasonable adjustments haven't been made to allow that person to attend an interview. Or for example, a woman with primary childcare responsibility might complain of indirect sex discrimination if she's only offered interviews in the evening when otherwise she has to look after her children, for example. So as an action point, I think all employers need to think outside the box as to how your recruitment process is coming across to the market. Does it disadvantage any particular group of people? And also to think about your job adverts as well, because they can be vulnerable under the anti-discrimination laws as well. And of course, if you have any doubts or questions, feel free to contact us. And I think it's worth pointing out that it's just not only job applicants that can theoretically bring a claim of discrimination in respect of an employer's arrangements, okay? So it doesn't have to be a job applicant or even a successful job applicant. It can be somebody that has seen a job advert and ultimately took issue with it and thought it was discriminatory, and that person and plus many other people can bring a claim in that regard. So just be very careful about your adverts and what message they put out there, and just again think critically about them. Any doubts or questions, definitely drop us a line. If you are unfortunately running a discriminatory advert, the harassment provisions in section 40 of the Equality Act only apply to those people who've actually applied for a job. Okay, so not that we should be splitting hairs this much, but ultimately there's a legal distinction between a huge category of people who can bring a claim if they don't apply, but only those that apply can bring a harassment claim. Okay, also, aside from the risk of claims by individual job applicants or individual potential job applicants, an employer who publishes a discriminatory advert might actually face enforcement action from the Equality and Human Rights Commission, the AHRC, under powers granted by the Equality Act 2006. Okay, and the AHRC can actually bring an injunction against the company or a person if they believe that, for example, that the job advert is discriminatory. And just one other final point about job adverts is that if somebody is bringing a claim because they found an advert offensive, then, and again, it can be very subtle. It can be, there's a lot of talk about adverts being potentially age discriminatory in terms of looking for somebody who's young, vibrant, energetic, or something like that. You know, that could be directly or indirectly discriminatory on grounds of age. But a person bringing a claim would, who hasn't applied for the job, would need to show that they would have applied for the job, but for the discriminatory advert. Okay, so just bear that in mind as well. Now, again, the second thing I wanted to speak about here briefly was who can be liable under the pre-employment discrimination provisions. And once again, this is very wide, so claims can be brought against the employer. It could also be, claims can also be brought against the employees involved in the recruitment process as well, much to the shock of many people, I can imagine. And thirdly, claims can actually be brought against recruitment agents who are responsible for the discrimination in question. And this all comes about, or it's actually explained by the explanatory note to the Equality Act, which says that the Act wants to ensure that both the person carrying out the unlawful act and any person on whose behalf they were acting can be held to account where appropriate. Okay, So the employer can obviously be liable for the activist employees in the recruitment process due to vicarious liability. So you just need to be careful about comments, things said in the interview process, asking not great questions, and all the arrangements that, as I mentioned earlier. In addition, the employee can be sued individually for knowingly helping the employer to discriminate. So again, employees should receive training about how to run a fair and discriminatory-free recruitment process. I'll come on to that. And lastly, the recruitment agent. So I know some of you attending today are working in recruitment agencies. So this goes two ways. So a recruitment agent can make the employer liable by, again, the concept of vicarious liability. If the employment agents or the recruitment agents are acting on the employer's authority, okay? And that's regardless of whether the employer has knowledge or approval of specifically what they're doing, but they can bring liability to the doorstep of the employer. And secondly, or lastly, recruitment agents as employment service providers can actually be sued by job candidates as well, okay? As well as publishers of job adverts as well. So again, they've made this quite wide under the Equality Act. And just one sort of final action point here, which is that it's strongly recommended to give your staff, all the staff who are involved in the recruitment process, just really solid training on this. Again, any questions, just let us know. Just because the liability can be actually quite wide-ranging. And I think with today's sort of cancel culture and the current trend of people being much more prepared to stand up for their rights these days, which I think is great, you've got to be much more careful about and again, it's not the obvious things that you do. It can be something fairly innocuous that actually give rise to multiple discrimination claims and obviously severely damage the employer's reputation as well. So staff training for those involved in recruitment is absolutely critical. Just one final point, which we don't have time to go into today, is about artificial intelligence. And particularly larger employers are using artificial intelligence to within the recruitment process to kind of filter down through people or searching and things like that. And it's just to let everyone know that managers should receive training on how to use AI as well, just to make sure that any potentially discriminatory patterns or processes are just kind of spotted and rooted out, because the software or the computer system can actually produce results that could be discriminatory. So not enough time to go into all of that today. It's quite an interesting topic, but I just wanted to mention that lastly. Okay, and that is all for me. So so I've just got the chat box here to have any questions. Okay, let's have a quick look. So a question from Sarah. So she's saying, just to clarify, if you're a small employer and you haven't registered to sponsor workers to work in the UK, is it correct that you cannot advertise roles requiring only those who have the right to work in the UK? This could be discriminatory. Okay, that's a question about, I think it's more like a recruitment question, actually, but I think without researching the issue, and Carl and Harriet, feel free to chip in as well if you want to, I think that ought to be fine, okay, because if you did hire them in absence of having the right to work and the right to live and work in the UK, then ultimately I think that would be, if you did hire someone in breach of that, the contract would be illegal, and that does tend to trump a whole host of other things.
Can I jump in, Dean? I'm happy to just because I was going to cover just this a little bit in the section that I was going to talk about. And Dean's absolutely right. Obviously, if you actually employ somebody who doesn't have the right to work in the UK, that's a big no-no. But you're right to ask the question, Sarah, because when it comes to advertising the job, you do need to be very careful that you're not at the advertising stage putting off people who may not then apply if you're saying that you put certain conditions on the job advert, and you should only ask about eligibility to work at a later stage when you're actually at the offer stage of the process. So yes, I think you're right that you shouldn't advertise roles saying only those who've got the right to work in the UK up front. It needs to be open to everybody. And then once you get to the stage and you've interviewed people, you can make the offer conditional on somebody having the right to work in the UK, and I'll talk about that a little bit in a minute, because otherwise you can get yourself into tricky situations where people may say, well, you didn't want to interview me because you just presumed I didn't have the right to work in the UK, or whatever it may be. But Dean's absolutely right, you're not actually going to be able to employ somebody who doesn't have the right to work in the UK, but it's best to just leave that out of your job advert at the early stages, would be my view.
Okay, that's great. Thanks, Harriet. And I think that's all from me at the moment. Obviously, any further questions, just keep them coming through. And Harriet, I'll hand over to you to talk about a whole heap of employment law problems regarding recruitment. So over to you, Harriet.
Okay, thank you. So yeah, I'm going to sort of look at the next stage when you're looking at you've had your advertisement, and you're looking at the next step of actually making the offer of employment. And as we've just sort of discussed, you can make it subject to certain conditions. And I want to have a little look at, well, what happens then if those conditions are not satisfied, and also then if the employer wants to withdraw the offer after it's been accepted, what happens then, or if the employee actually backs out of starting the job having accepted the offer. So a few things to look at there. So if you want to make the offer subject to conditions, which often is a really good idea, you need to make sure that those conditions are absolutely clear to the employee. And obviously you're going to want to put these in writing, because if you don't express them sufficiently clearly, you might not then be able to rely on them to say that the contract then isn't binding if one or more of them isn't satisfied. So make sure you put them in writing, make sure they're really clear to the employee. And some examples of conditions that you might want to include, which you usually see in the offer letter, will be things like receipt of satisfactory references, confirmation the employee is free to work in the UK, as we just discussed, or has the appropriate immigration approval to work in the UK, receipt of a medical report or completed medical questionnaire, which is satisfactory, and I'll come on to that in a bit more detail, confirmation of holding certain qualifications, being free from any post-termination restrictions from previous employment that would prevent them from starting work. Carl's going to come on to that, so I won't look at that in detail, but that's obviously a really important one. And if they were going to hold office as a director, you want to make sure that they can confirmation that they're not subject to any restrictions that would stop them from doing that. Maybe background checks that may be required professionally due to the nature of the job that you're offering, or obtaining any particular qualifications that are required. So obviously what conditions you need to make the offer subject to depend on your business and the particular job. So if the employment contract includes an entire agreement clause, which many contracts do, you need to make sure that these conditions are satisfied before you enter into the contract. Because if the employee actually starts work not having satisfied the conditions, there's then a risk that by starting employment, that might indicate an intention to create legal relations that might give rise to an employment contract, even though the conditions haven't been met. The downside, if that is the case and an employment contract has come into an existence, is that the employer will just have to provide notice required to terminate it. And I'll come on to that in a little bit. But yes, ideally, you would want to sort of be able to stop things progressing before a contract has even come into existence. So just looking at a couple of these conditions, firstly, references. I think most employers are going to want to make an offer conditional on receipt of references which are satisfactory to the employer. And again, ideally, you don't want a contract to actually exist until the references are received. And if you don't include this condition in your contract, if you then look for references and then they're unsatisfactory, if you don't want to go ahead with the job, you then may have to give that individual contractual notice or make a payment in lieu of notice. And depending on how long the notice period is, that's probably something that you'd rather have to avoid. Whether or not a reference is satisfactory to the employer has been held to be subjective. So really it's up to the employer what they consider to be satisfactory. But you need to be a little careful, because if you withdraw a conditional offer having received the reference, for example, that may indicate high levels of sickness absence that may be due to a disability, obviously you may then become liable for unlawful discrimination, as Dean's referred to, because the individual may rightly say, well, I think you've withdrawn the job offer because of information you've received about my disability, and that's not necessarily going to be lawful. So do be very careful about the specific circumstances when withdrawing an offer, having received a reference. And you will always want to document those reasons and make sure that you put them in writing, so it's very clear that if you do then get challenged, you've got contemporaneous evidence to support why you decided to withdraw that offer. Then just referring to permission to work in the UK, again, as we've discussed, employers have a duty to prevent illegal working by carrying out the prescribed document checks on candidates before employing them to ensure they're lawfully permitted to work in the UK. And that's really important that it's done before someone starts working. And I know sometimes it can be very easy for, you want to get somebody on board, they start working, you say, well, we'll get the contractual documentation sorted out as soon as we can, but they've actually started. And then the issue crops up, oh, right, do they have the right to work in the UK? Have we done what we're supposed to do? So it needs to be very, very careful that you do that before they start work. And as you said, in order to avoid claims for race discrimination, you want to make sure that you're asking the same questions of all applicants regarding permission to work in the UK at the relevant stage of the recruitment process. So if you're making a job offer subject to permission to work in the UK, make sure that all your offers of employment have the same condition, not just those people who you think may not be of British descent. So again, you do need to be a little careful. And there is a Home Office guide called, it's a code of practice for employers called Avoiding Unlawful Discrimination While Preventing Illegal Working. And that's really helpful with some really good guidance on this area. So again, eligibility to work in the UK should be verified at the final stages of the selection process rather than the application stage, to make sure the appointment is really based on merit alone and isn't influenced by other factors. I'm just looking briefly at medical reports and questionnaires, because depending on the nature of the role, it may be appropriate to make the offer conditional on receipt of satisfactory medical report or medical questionnaire. Just obviously remember that if you do this, that may give rise to some data protection issues, because asking for the medical information will involve processing special category data. And remember that employers aren't allowed to ask potential recruits questions about health other than for prescribed reasons. This is before you're at the offer stage, and there's section 60 of the Equality Act covers this, and it just says that other in some very limited circumstances, if somebody is applying for work, you mustn't ask them about their health before you're actually offering the job. And the limited circumstances could be things like, if there was a function that was absolutely intrinsic to the work, or if there was some sort of assessment process, whether that individual was able to actually undergo that assessment. So those circumstances are very limited. But when you get to the offer stage, you can make the offer conditional on satisfactory responses to pre-employment disability or health inquiries or satisfactory health checks. But obviously, once you've received the response to those, you mustn't then discriminate against the job applicant on the back of that. And obviously, if somebody was disabled, you would need to make sure that you then do make reasonable adjustments for that individual. And obviously, you can only, should only be asking health questions that really are relevant to the particular job. So obviously, give that some good thought before you ask those kind of questions. So moving on now to withdrawing the offer. Now, obviously, an employer may wish to withdraw an offer for a number of reasons, and we do quite frequently get asked these questions from clients. It could be because the business requirements have changed. You might have unexpectedly received information about the applicant, which changes your mind about wanting to employ them, or one of the conditions of the offer, such as receipt of satisfactory references, hasn't been fulfilled. So there could be quite a lot of different reasons why you might want to withdraw that offer. But obviously, if you do that, be prepared that the individual may not be very happy, maybe rather disappointed, and they may try and challenge that decision. They may try and say that that's unlawful, that there's an act of discrimination. So as I said before, make sure that you've got any relevant documentary evidence that supports that reason for deciding to withdraw the offer. So what are the consequences of doing this? Well, unless they've got any relevant continuous service, so if they had been working for the same employer or an associated employer and you were just offering them a new position, they may have some continuous service, but otherwise they're unlikely to have sufficient continuous service to bring an ordinary unfair dismissal claim, for which obviously you need 2 years service. Just remember there are some exceptions for automatically unfair dismissal claims where the employee doesn't need 2 years continuous service. They're going to apply probably quite rarely in this kind of situation, but just remember that. And obviously the most obvious one is the discriminatory reason where you don't need any qualifying service. And things like receipt about health information are quite a sort of classic example of that. Withdrawing an offer, it might all have implications in contract law, because it will depend on whether or not the offer is withdrawn before or after it's been accepted, and you may risk a claim for breach of contract. So before acceptance by the employee, it can be withdrawn at any time, because at that point you haven't actually created a contract. There's been an offer that hasn't been acceptance, and you need both to create a contract. So you're going to want clear evidence that you withdrew the offer before the employee appeared to accept it. And that withdrawal should be clearly communicated to the prospective employee. So again, you're going to want to put that in writing and have your reasons for doing so. So what if the employee has already accepted that offer? So once the conditions have been satisfied and the employee has accepted the offer, there will be an employment contract. Doesn't mean that you can't terminate it, but you're going to have to give them the notice that they're entitled to under the contract. And if you don't, that would then be a breach of contract. But remember that the loss that the employee is going to suffer, so if they're going to claim for breach of contract, what is their loss? It's normally only going to begin to accrue after the date on which their employment was due to start, because until they've started work, they're not likely to be entitled to any benefits or pay. So an example could be if the employee has a 4-week notice period, but the employer then wrongfully terminates, i.e. you don't pay them for the notice period, 1 week before they were due to start work, the damages for the notice period would normally be limited to only 3 weeks earnings, because your notice has already started 1 week before they were due to work. So don't assume you have to pay them for the full amount of the notice period. It depends, when were they due to start, when are you giving notice, and if you ever come up with that query, obviously we can help you out with that. It can be a little complicated. So what about if the employee changes their mind? Well, if they've accepted the offer, the conditions have been satisfied, again, there's going to be a contract in place, then the individual is going to need to give you that minimum period of notice to terminate the contract. And if they don't, then the individual is going to be in breach of contract, and the employer could have a potential claim against the individual. However, it is very rare for an employer to bring a claim against an individual in this situation, because the employer is it's going to be quite likely for it to be hard to show what loss you've actually suffered as a result. It could be that you have a very valuable employee and you've got some contract that's contingent on them joining, and then they suddenly don't turn up at the last minute. There may be situations where an employer does clearly have loss, or you spent an awful lot of money recruiting that particular individual, for example. In some cases, it is possible to include what's called a no-show clause in the employment contract, and that means that the individual would have to make payments to the prospective new employer if they ended up not joining. And there was a case about this where that kind of clause was upheld in those particular circumstances, but they're probably going to be quite rarely used, maybe only where someone very valuable is joining in a role which is very important to the employer, and also it's going to be a question of fact in each case whether or not a penalty, whether the clause is a penalty clause and therefore unenforceable, because you need to be able to sort of predict the loss you're going to suffer, pitch the payment at that level. So it's something that's possible to do, but you need to pitch it right, and probably only where there's an awful lot at stake with that individual joining. And then lastly, I just wanted to talk about what happens if you discover that an employee has lied during the recruitment process. You may discover, you make them an offer, they enter into the contract, maybe they even start work, and then you find out that they've lied on their CV or their job application or other information that's been provided. You may want to then try and retract the offer and terminate the contract. So there's 2 ways really that you can go about this. Firstly, could be dismissal without notice, and that may be justifiable where the dishonesty involved is significant enough to amount to a repudiatory breach on the part of the employee, and that may entitle you to treat the conduct as a breach of trust and confidence, and you can bring the employment relationship to an end without having to give notice. Alternatively, you may need to give dismissal with notice, and then you can obviously give them the notice under the contract. Assuming they don't have the 2 years service, they can't bring a claim for unfair dismissal unless there's an automatically unfair reason. So, for example, they're alleging that actually the dismissal is for a discriminatory reason, potentially victimisation. And there was was a case where an individual applied for a job with a large bank, and they were asked questions in a pre-employment application form as to whether or not they'd ever been the subject of UK proceedings, and the individual said no. And then after the individual had started, they had the litigation that they'd had with another large bank was revealed in the press, and the current employer actually dismissed her. And what they said was, well, because you had lots of opportunities to tell us about this, we asked you a question about it and you said no, that's a breakdown of trust. But the problem was, is because it involved a discrimination claim, what ended up being decided by the tribunal was actually the reason why the new employer dismissed them was because they had brought a discrimination claim rather than because she'd failed to disclose it. I think they were just very upset, that they'd employed someone who had the audacity to bring a discrimination claim. So in this case, they then potentially were liable for victimisation for discrimination, even though they thought that the individual was the one who was in the wrong because they'd supposedly lied by not disclosing information that had been asked for. So yeah, do be very careful if you're going to terminate in these reasons, and think carefully about what the reason is, and make sure you can justify it and document it very carefully. So yeah, that's all I wanted to cover. Thank you.
That's great, thanks, Harry. And I think it's worth mentioning as well that I've had sort of numerous inquiries from clients over the years where they've made a job offer, some quite senior, and then it's disclosed last minute. Or, for example, I don't know, this person's got a problem with alcohol, or they see something in social media, and then you get the phone call saying, we'd like to withdraw. We don't want to hire this person anymore. And it's that risk of discrimination claims, or I don't know if there's any whistleblowing or anything actionable that people often don't really realize exists, because alcoholism could be linked to depression, could be linked to a disability, and so what is seemingly an innocuous situation could be quite dangerous for the employer as well in the wrong circumstances. So yeah, we do get lots of inquiries about all sorts of different things about recruitment. And just before we move on to Carl's section, Harry, there were two questions in about actually it's about way back to the job adverts as well. Okay, I believe you already answered them, but maybe we just run through them super quickly. Okay, so there's a question here from Nicola, I think, and she's asking whether we can ask about the right to work at the screening stage, and Lindsay is asking, can you ask filtering questions at the advert stage on making eligibility to work in UK a condition? So do you have a view on that, Harriet?
I mean, I think, if provided you're asking the same questions of everybody, I think the danger is if you're asking questions that may then discourage other people from applying. But I think obviously somebody has to have the right to work in the UK to be able to do the job ultimately, because otherwise, as you said before, you can't employ them if they don't. But I don't know whether or not normally people feel that they have to say that, because I'd expect that most job applicants would realise that they had to have a right to work in the UK to actually undertake the job. So I don't know whether in practical terms this is an issue that comes up. Normally what you'd want to make sure is if you make a job offer to somebody, before they actually start work, you have that evidence that they do have the right to work in the UK, because you can't employ them if they don't. But I don't know whether it really, I don't know, maybe I'm wrong, whether it's an issue actually.
I think you're totally right. I mean, the safest way to do it is not commercially great for the employer, but once the offer's made, then you lock it into the offer documents, which you have to as a matter of law. And asking it prior to that could give rise to discrimination claims, because it could discourage people who don't have the right to work in the UK, who may be getting it or could get it if the employer is a sponsor, But Carl, over to you.
Yeah, no, it just reminded me of a case I remember reading it a long time ago. It's Osborne Clark Services and Purahit, and it predates 2008. But essentially, Osborne Clark Services had a policy of only advertising for training contracts, making it clear in the advertisement that they wouldn't offer it to non-EEA nationals, so those who live in countries outside of the European Economic Area, which is not just the EU as it was back before 2008. It's wider than that. Liechtenstein, etc. And then I think it was an Indian national that sued, saying, well, that's indirectly discriminatory, because as an Indian national, I don't have UK citizenship. I'm not a citizen of any EEA countries. I can't satisfy that criteria. and it was held at EAT level, Employment Appeal Tribunal level, that it was indirectly race discriminatory for that requirement to be placed in an advert. And that's because the number of people of non-EEA nationalities who could comply with it was much smaller than a comparison group of the people who could comply with it, i.e. those who live within EEA countries. That's quite an obvious thing, as in it was obvious that people outside the EEA would struggle. They wouldn't be able to match this criteria. So Osborne Clark tried to justify this by saying, well, there is a resident labour market test, and we're required by immigration laws to make sure that we can only offer jobs to people outside the EEA if we can't find people with the same qualifications within the EEA, or for those who have fewer qualifications, they can be trained up in a short period of time. And they tried to rely on that to justify their advert. But they failed on the basis that they couldn't come up with sufficient evidence to show that they had discussed it with the UK Border Force or followed Home Office guidance as it was at the time, as to whether or not these people from outside the EEA could obtain the work permits or not. So I think, as Harriet pointed out, definitely read the advice, the latest Home Office advice on avoiding discrimination in the context of recruitment. Read that carefully. Bear in mind then what your own adverts say, or what you wish them to say, and make sure it complies with that advice. My view about this is that the lesser of two evils is to be sued for discrimination in the employment tribunals, because that's a civil wrong and you may have to pay out some money if you're found guilty. What you need to do is avoid any criminal liability from hiring someone who doesn't have the right to work in the UK. That's the most important thing to adhere to.
Yeah, I think big echo. Sorry, right. I think again, as long as there's a sensible and structured recruitment process where the right questions are asked at the right times, you can hopefully avoid both, I think, which is, I guess, what we're mentioning. Right, and I'm just going to say as well, just before we move on, if anyone does have any specific, if you want your recruitment process sense checked from a discrimination perspective, definitely drop us a line. Me, Carl, Harry would be delighted to help. You can get us via me on dean.jones, Jones, @jonechase.com. I'd be happy to have a quick chat with you as well about whatever kind of issues you're facing, because one of the risks of the webinars is it's such a broad brush approach. We don't really know the facts that we're discussing, so we're giving very generic advice. But happy to have a chat about any specific issues that you may have. Okay. So moving on to the final section for today, which is Carl's section. Very widespread, so very commonplace as well. You are an employer, you're about to hire somebody who's a fantastic candidate. However, they are covenanted up to the hilt and they're leaving a competitor. Can you hire them? What do you do, etc.? What are the legal issues, commercial issues, and financial issues? So, Carl, over to you.
Yeah, sure. Well, I mean, the first thing to bear in mind is that the potential joiner, person you want to hire, I mean, there's a reason why you want to hire them, obviously, and you can go ahead and hire them. But I'm going to outline in brief some of the things you need to look out for, and the risks, the legal risks, as you as the potential new employer, if you go ahead and hire them with the knowledge that they are subject to what's called post-termination restrictions or covenants, is another one. So essentially, the law recognises something called an economic tort of procuring or inducing a breach of contract. Now, this is a civil wrong that applies to all contracts in all areas of commercial endeavour, all walks of life. It's not unique to employment law. However, where we come across it is in the context of covenants, where a new employer will say to us, we found this excellent senior executive, or someone else who doesn't have to be a senior executive, we want them to join. They've got covenants with their existing employer. How do we bring them over, and what risks are there for us if we hire them as an employee or contractor? And the thing to bear in mind is that the way in which this tort works, inducing or procuring a breach of contract, is it requires the following elements. The first element is that the party who is the potential breacher, who's going to breach the contract, which is the individual employee, by the way, they need to be subject to a valid contract. It needs to be an enforceable contract. So we will explore whether or not the current employer has done anything that amounts to a fundamental breach of that contract. And if so, has the employee resigned in response? Why are they leaving? Why are they leaving their current workplace? If the contract is still valid and enforceable, and the covenants sit within it, we will then look at whether we think the covenants are enforceable in law or not, bearing in mind the touchstone legal test, which is do these covenants go no further than is reasonably necessary to protect the legitimate business interest? And you have to look at the way in which the covenants work. You have to apply to them a meaning. What are they getting at? And these covenants range from things such as a non-compete, preventing the employee from joining a competitor for a period of time, as well as a non-solicit, so preventing them from taking any proactive steps to try to solicit the clients or prospective clients of their current employer, non-poach of key employees, i.e. to prevent team moves, etc., and also non-deal. And the non-deals are the most wide-ranging because they apply not only to proactive steps by the employee, but also situations where a current customer they're dealing with or client finds them of their own volition through their own research via LinkedIn or elsewhere. So, and there's also non-interference with suppliers. So those are the sort of covenants that one sees quite regularly. Once it's established that there is a valid contract in place, these covenants are there, we assess as to whether we think they're enforceable or not if the new employer comes to us or the employee, him or herself, comes to us for advice. The way in which this sort of liability, this sort of tort bites is if you, as the prospective employer, has knowledge of these restrictions and you intend as a legal outcome that something you want this employee to do once they join your business is going to amount to a breach of one or more of those restrictions that I've just outlined. So valid contract, the covenants need to be enforceable as a matter of law, i.e. do they go no wider than is reasonably necessary to protect a legitimate business interest? And third, has the employee, once he or she's joined you, done anything which amounts to a breach of one or more of those restrictions? And then the fourth element is, have you had knowledge that the outcome of what you would ask them to do, what you're trying to get them to do when they join you, is a breach of their contractual covenants with their old employer? And on that note, then a lot of the case law in relation to inducing a breach of contract focuses on what is required, what is the correct test to apply to identify whether the new employer has the requisite level of culpable knowledge of the covenants so as to give rise to liability. And I'm reminded of the case of Allen and Dodd and Co Limited of February 2020. I know that we're all busy doing other things because of COVID last year, but this was a Court of Appeal decision, so it is almost it's binding on High Court, not binding obviously on the Supreme Court, but it did look at a Supreme Court decision in OBG, which was decided in 2007. And in this case, Lord Justice Lewison made it clear that what was interesting about this case was that the defendant, so the new employer, Dodd & Co, an accountancy company, said, well, wait a minute, we didn't have knowledge such as to give rise to liability for us inducing a breach of contract by this accountant who we've sort of poached from a competitor, because we got legal advice at the time. The legal advice said that in all probability the covenants are unenforceable because they're too wide-ranging. They last for 12 months and that's too long. This is in respect of non-solicit and non-compete. So they then got more information from this employee before he joined them, and they fed that back to the lawyers, and the lawyers updated their advice but stuck with the same conclusion, which is that they're unenforceable. These covenants are unenforceable in law. They go too far. So Dodd relied on that, got this accountant to join, and then immediately got him to chase up all the clients that he was dealing with at the previous accountancy firm. And of course that resulted in High Court litigation, because these things are litigated in the High Court, they're not litigated in the Employment Tribunal, so you've got to be aware of that. And the judge basically held that, consistent with previous case law, it's not the case that in order to avoid liability, the defendant, which would be your company here if you were to hire someone in a similar situation, it's not the case that you have to show that you had an absolute belief that you weren't breaching a contract, you weren't getting the new employee to breach the contract. It's just the case that you just have to sort of be 51% or more aware of the belief or of the view. So more probable than not of the view that what you're getting this new recruit to do is a breach of their valid existing covenants. And this is quite important because it gives new employers a sort of, I'm not going to say get out of jail free card, of course not, but it gives them greater scope to say, we've gone and got legal advice. It doesn't matter, as a matter of law, it doesn't matter if the legal advice is wrong. If the legal advice says the covenants are unenforceable, go ahead. But that turns out to be wrong. It doesn't matter. You can rely on the fact that you have sought legal advice to inform your position, you relied on that legal advice, and the law recognises that you should be able to rely on that legal advice, even if it is wrong, so you avoid liability. And what the barrister argued in Allen and Dodd for the old employer that was disgruntled by the decision at the first instance High Court said, well, look, wait a minute. If you go down that route, what you're doing is you're encouraging people to get dodgy advice from dodgy lawyers that say, oh, don't worry, the covenants are unenforceable, go ahead, here's a bill. And or that you're encouraging new employers to feed wrong information to their lawyers, such that the lawyers say, oh, it is unenforceable. But the judge said, look, we can deal with that, because in order to rely on legal advice, even if that legal advice is wrong, that what you want the employee to do doesn't amount to a breach of the covenants. You just have to have a genuine belief in that legal advice. So if you fed wrong information to your lawyers and deliberately held back information, then you can't establish honest belief. So you do have to have an honest belief in what your lawyers are telling you. And so my view, actually, bearing in mind that these things are litigated in the High Court, where if you were found to be in breach because you've procured or induced a new employee to breach covenants that they're entered into with their old employer, you will be held, if you're found liable for that, you will have to pay the fees of the successful old employer, and the legal fees can be quite expensive, certainly much more expensive than getting legal advice early on from lawyers as to whether the covenants are enforceable or not. So just being purely economic for a moment, it makes sense to spend a little bit of money on getting legal advice on these covenants of a potential new joiner, rather than risk it and ending up in the High Court losing and having to pay the other side's out of legal costs. Now, tactical considerations. Well, I think tactical considerations are, as I've said, obtain legal advice early on. Don't rely on the employee saying, the new joiner saying to you, oh, don't worry, I've spoken to a lawyer friend of mine, and they say it's all fine and these covenants aren't worth the paper they're written on. And the reason I say that is because you'll then be aware that the covenants exist, and it's been held in OBG versus Allen, which is a Supreme Court case in 2007, as well as earlier cases, that turning a blind eye to the existence of restrictive covenants is treated as equivalent to actual reckless indifference or a willful failure to inquire into a fact. And both of those things are treated as knowledge of the fact, knowledge of the covenants being in existence. So simply by sort of saying, look, just come and join us, do all the following things, steal your clients from your previous firm, I don't want to know what your contract of employment with them looks like, won't get you out of problems, because turning a blind eye is equivalent to being aware of the existence of the covenants. And I think just be aware also that if you are at the sharp end of such a claim of inducing a breach of contract, and certainly when we are instructed on behalf of the old employer, we always probe around and try and identify who the new employer is and send them a letter saying we believe that you're inducing a breach of contract for the following reasons. And one of the reasons why we do that in pre-action correspondence is we're trying to tease out replies that could be quite useful for us if we want to frame a claim in the High Court. Just be aware that if you do fail and you are found guilty, the head of damages for a tortious claim of this type is any financial losses that directly flow from the tort. So it's broader than breach of contract damages, because you don't have to show in tort that the losses were reasonably foreseeable. That doesn't apply. So you're potentially on the hook for kind of more costs than you otherwise would be, higher damages award. And defending a claim in the High Court is expensive. So if you get legal advice, so all these things, I think early legal advice, minimise risk. You certainly put a clause in your employment contract with a new joiner that he or she warrants and represents that they aren't subject to any obligations or duties owed to any other parties, which would prevent them from taking up work that you're asking them to do. Because then if you do receive pre-action correspondence threatening a breach against you, a claim against you, you can use some of that information to justify perhaps terminating the employment contract. And if it's already been offered, then you can't withdraw it, as Harriet's pointed out, but you could look to terminate. The other thing to bear in mind is often these things are threatened early on when the new joiner joins you, because that's when the old employer finds out quite soon after. And so have a clause in your employment contract, which is a probationary period, so that if you do want to serve notice and terminate that new joiner joining you, then you only have to serve short notice, and you're not on the hook to pay 3 or 6 months notice. And I think another tactical consideration tends to come from the new joiner, because I'm conscious that some of you here may have friends who are in this position. And the new joiner may ask you for an indemnity. So they might say, well, I want a deed which says that in the event that I'm sued by my old employer for doing something that you asked me to do when I join you, you pay for my legal fees in defending such a claim in the High Court or any other court, as well as any damages that flow from my breach. And if I ever act for an individual, I always ask for indemnity, because my aim is to act in the best interest of my client, and I don't want to be exposed to potentially very high value High Court claim litigation. And you get the measure of the value that your new employer places on you if your new employer agrees to give the indemnity or not. So just bear in mind that may come in. They may ask you for indemnity, and you really have to focus your mind as to whether you're going to agree to it, and you have to be very careful in what you agree to, because an indemnity can be very expensive indeed. You don't quite know at that early stage what the employee's done. Have they copied loads of confidential information they haven't told you about? Were they just going to rely on it in their new role without feeding it to you directly? You might not have also all the skeletons in the closet coming out at the same time. So bear that in mind.
Yeah, that's great. And just to jump in, we've had a question from Rosie. So Rosie, we will come on to that in a second. But I guess Carl or Harry as well, and just on this topic, whenever we get instructed by either an individual or a company looking to hire somebody, and there's restrictions, as you said earlier, the first thing we do from a tactical point of view, well, we look at the contract. Are they drafted well? Are they any good? Are they likely to be enforceable? And then if a lot of people assume that a non-compete is something like a non-solicitation of customers point, but it's not a non-compete. A non-compete stops you from working somewhere. So you can still take up employment with that company, but just leave the other customers alone. So that we're always looking for wriggle room and always looking for options. And if there's no restrictions that prohibit the problem that you need to, that you're worried about, then you're great. If there are well-written restrictions that are likely to be enforceable, if there are well-written restrictions, you then need to look at, are they enforceable in the case in question? Is there a legitimate business interest to protect? And also, Carl, something that we've done an awful lot in the case that we've worked on is then you can do a deal on undertakings. You can undertake not to solicit customers, not to steal employees, as long as they'll allow you to work for this other company and earn a living. So you can usually do a deal on with undertakings as well before it gets to the code stage, right?
Yeah, sure. I mean, so undertakings is essentially a sort of form of a worded commitment by the employee not to do certain things, and there's nothing to stop the new employer from agreeing to do their best to procure that employee will comply with those undertakings. Just be careful with undertakings. I have had situations before where the old employer's lawyers have sought to draft undertakings, i.e. setting out what the employee won't be doing, wider than the initial restrictive covenants they signed up to in their employment contract. So you have to really be quite nerdy and check the wording. And also, if there's any evidence that the employee signs undertakings but then breaches them, you're almost certainly going to get an injunction, because the legal test involved in deciding whether an equitable remedy of injunction will be granted, which is the sort of balance of convenience, will tip in favour of the old employer if there's evidence of breach of the undertakings. So you've got to sort of have a bit of trust as well that the individual who's signing these undertakings is going to heed to them and knows the importance of heeding to them.
That's right, and I think it's the view of the firm as well, is that there's always options, there's always something that you can do in this scenario, rather than just think, oh, well, we can't hire that person. If they're a real key hire, there's almost something that you can do, if you just plan it well. Just conscious of time, and we've had a question from Rosie prior to the webinar, and Carl, this is one for you. So Rosie's said that she's thinking about the balance of power between the employer and the employee at the recruitment stage. And she's very interested in the typical levels of employee to whom it is reasonable to include contractual post-termination restrictions and what they reasonably might be. So Carl, this is your section. Do you have
some of the earlier case law on enforceability or otherwise of post-termination restrictions involved hairdressers, believe it or not. So when a hairdresser would leave, they may grab the black book of all the clients under the reception desk and run to the competitor, half a mile down the road. So I think my answer here is, it's not so much a question of whether someone's senior or not. It's a question of what access to confidential information will they have or likely have. What exposure do they have to our clients or customers? What influence do they have in understanding the contractual terms that we have with our clients and customers? Can they see what we charge for pricing? Do they have access to our suppliers? Do they choose who the suppliers will be? Will they be able to influence the people that we need to deal with in order to make a living and sell our goods or services? And so that could be someone actually relatively junior in their hierarchy. I appreciate a more junior person may not have access to the same level of confidential information, but they nonetheless may still have a lot of client-facing time. And then the question you need to ask yourself is, with all of those with all those considerations in mind, what we want to protect our goodwill, the loyalty and our trade connections with our clients and customers, and our stable relationships with our suppliers. There we need to draft and craft restrictions to apply after they leave. And I think just be aware that if you impose lengthy period of restraints, so say for example 12 months or 9 months or 12 months on someone who is lower in the pay scale, and you apply a shorter period of restraint to someone higher up in the pay scale, there will be a question as to why is there a difference in level of protection sought, and you have to be able to explain the difference. What you don't want to do is create a rod for your own back for people to say, well, my manager's manager has only got 6 months, you could be 9 months, therefore 9 months isn't legitimate.
Yeah, that's great. And just conscious that I did say I thought we'd finish early. We never ever do, to be fair play. Yeah, and just finally on this question, I think Rosie, so it's good to start with the just think, what is the legitimate business interest that we wish to protect, and then work backwards from that. And that can apply to very senior or even more junior employees. As long as there's a legitimate business interest that you're looking to protect with these restrictions, that really answers the question on two fronts, as in who should be subject to them and also what restrictions should there be. You shouldn't just put restrictions in which have no commercial relevance whatsoever, I think. For example, I don't know, if someone literally is internal facing, like a finance director, has no contact with clients, you're not going to be overly worried about non-solicitation. You're more worried about non-competes there, for example, okay? Or non-poaching of staff. So yeah, work at what the legitimate business interest is you wish to protect, and work backwards from there in terms of drafting. Okay, 1 minute to 5. Well, thanks very much for attending the webinar. Thank you so much for supporting us with this project. Really appreciate it. So just a quick reminder, the information that we covered today is accurate as of 4 o'clock on the 21st of October 2021. We are doing an annual annual conference next month. We're just looking to, we're finalising the preparation for that now. Would love to meet some of you face to face, sort of COVID depending on all of that, but within the week there'll be an invitation coming out to all of you about that. So thanks very much for attending, and that's all from us today. Yeah, I think then we're good. Okay, and we look forward to seeing you at the next webinar. Okay, take care, guys. Thanks so much.
Thank you.
Bye.
Take care, everyone. Bye-bye.